Namaste, good morning. Yes, very good morning and welcome. Hope you guys are doing good and hope you guys have revised the previous class topics. Okay, yes. So, in the previous classes, we discussed about the Indian Partnership Act 1932. So, tell me, the Indian Partnership Act 1932 deals with what? Partnership, where we have discussed what is a partnership, who are partners, rights of the partners, duties of the partners, dissolution of partnership firm, formation of partnership firm. All these things we have discussed in detail in the previous class. Okay, so in today's class we will discuss the one more chapter called as Limited Liability Partnership Act, LLP Act. So as the name itself indicates, this is the chapter which deals with limited liability partnership. It's a partnership, but liability is limited. So LLP is a hybrid structure of a company as well as a partnership. It's a combination of the advantages of both company as well as the partnership. That is why it is called as LLP, Limited Liability Partnership. Generally, in case of partnership, the liability is unlimited. But in case of limited liability partnership, the liability of the partners is limited. And one more thing is, in case of partnership firm, the number of maximum partners a partnership firm can have is how many? Maximum 50. But in case of LLP, it is minimum to maximum unlimited. Okay, so these are the unique features of what? Unique features of LLP, and LLPs are governed by which act? LLP Act 2008. The LLPs are governed by the LLP Act 2008. LLPs has the characteristics of both partnership firm as well as company. That is why we can say LLP is a hybrid structure of both company as well as the partnership firm. It's a combination of partnership firm and the companies. And the LLPs are regulated by the Limited Liability Partnership Act 2008. LLP structure is available in the countries like United Kingdom, United States and various Gulf countries, Australia and Singapore. In the same way, even in India, we have the LLP structure which is regulated by the LLP Act 2008, which came into force from the year 2009. Concept of LLP. The concept of LLP is explained as below. It is an alternative corporate business form that gives the benefit of limited liability of the company and flexibility of partnership. See, it comes with an advantage of both company as well as partnership. Sir, how sir? Company has limited liability, partnership has what? The flexibility means in case of partnership firm, there are no much intervention by the law. The partnership firm is managed as per the will and rules of the partnership agreement. But companies are governed by the Companies Act as well as MOA and AOA. So what they have done, they combine the benefit of partnership firm as well as the company, and they introduced a new type of entity called as LLP. That is why LLP has the benefit of flexibility of the company and the flexibility and liability of the partnership firm. Okay, it has limited liability of company, but it also has the flexibility of partnership. It can continue its existence irrespective of change in partner. A partnership firm ceases to exist in case of death or insolvency of a partner. But in case of LLP, it continues its existence irrespective of change in the partners. Partners may come, partners may go, but LLP goes on forever, like perpetual succession, like company. It is capable of entering into a contract and holding property in its own name. Sir, why sir? Why? Because LLP is a body corporate. So because LLP is a body corporate, it can hold the property in its own name and it can also enter into a contract in the LLP name itself. It is a separate legal entity and liable to the full extent of its assets. And the liability of the partners is limited to the amount of contribution they make to the LLP. Now, what is contribution, sir? Contribution, nothing but the capital. So, in case of LLP, it is called as what? Contribution. Okay. No partner is liable on account of independent or unauthorized actions for other partners. In case of partnership firm, there is a mutual agency relationship. Means for the act of one partner who is responsible, other partner is responsible. But in case of LLP, there is no mutual agency relationship between the one partner and another partner. So if a partner does something which is not authorized and beyond its power, who is not responsible? Other partner is not responsible. Okay, so these are the unique features or characteristics of LLP. It has the advantage of company, flexibility of partnership. It has perpetual succession, unlike partnership firm. It has limited liability, unlike partnership firm. It's a separate legal entity, unlike partnership firm. It can continue irrespective of death or insolvency of the partners. And one partner is not the agent of whom? Not the agent of other partners. And the mutual rights and duties of the partners in a LLP are governed by what? Governed by the LLP agreement. What agreement? LLP agreements. So the mutual rights and duties of the partners are governed by what? Governed by the LLP agreement. What agreement? LLP agreement. So this is how the LLP agreement looks like. Okay, so we make a LLP agreement and where we agree everything. So this is the LLP agreement. So whatever the rights, capital contributions, everything will be agreed by whom? Agreed by the partners in the LLP agreement. Which agreement? LLP agreement. So once you become a CMA, when you go for incorporation of LLP, you do all these things, drafting of LLP agreement, all these things practically. Okay? So unlike companies which are supposed to have two different documents, that is MOA and AOA, the rights and the duties of partners in an LLP is governed by which agreement? Governed by which agreement? Can I get an answers, please? What is the agreement which governs the rights and duties of the partners in an LLP? LLP agreement. What agreement? LLP agreements. Done? Am I audible to everyone? Yes. Now, LLP Act 2008. What is the Act? LLP Act 2008 is the one which provides the provisions with respect to LLPs. We have the 4 schedules, 14 chapters, 81 sections and 4 schedules. How many chapters we have in LLP Act? 14 chapters, 81 sections and 4 schedules. First schedule to the Act deals with provision with respect to the rights and duties of the partners. If the partnership agreement is silent, LLP agreement is silent with respect to any of the matters, then first schedule of the LLP Act is applicable. If it is agreed, as per agreement, not agreed, first schedule. Second schedule to the Act provides the provision with respect to conversion of partnership firm into LLP. So what is the formalities to be followed for the purpose of conversion of a partnership firm into LLP is governed by second schedule. Then we have the third schedule, which provides for conversion of a private company into what company? Into a LLP. Second one is conversion of partnership firm into LLP. Third one is conversion of private company into LLP. And the fourth one is conversion of unlisted company into LLP. Done? So, we will discuss Schedule 1, rights and duties of the partners. Schedule 2 with respect to conversion of partnership firm into LLP. Schedule 3 for conversion of private company into LLP. Schedule 4 is for conversion of unlisted public company into LLP. Okay. LLP means LLP is a partnership which is formed and registered under which Act? LLP Act. That is called as LLP. Next one. Who can become a partner? Section number 5 of the Partnership Act, LLP Act provides what? Provides who can become a partner of LLP. So any party, an individual or a body corporate can become partner of what? LLP. So what is body corporates are nothing but the one which is having separate legal entity. Companies, LLPs can become what? Partners of LLP. Now the question is, can one LLP be a partner of another LLP? Answer is yes, because LLP is a body corporate. Can company be a partner of LLP? Answer is yes. So any person, that is individual or a body corporate, can be a partner of LLP. Okay, yes. So the limited liability partnership, whether it is incorporated in India or outside India, all of these persons can be what? Can be a partners in LLP. Done? Yes. Next one. Company incorporated outside India, it is also a body corporate, can be a partner of LLP. But an individual cannot be a partner of LLP if he is unsound mind. What mind? Unsound mind. Or is undischarged insolvent, or he has applied to the court to be decided as an insolvent. In these cases, a person is disqualified to be a partner of what? Partner of LLP. And there must be minimum 2 partners in an LLP. Maximum is unlimited. Now tell me, I will ask questions to you guys. You guys should tell me whether can such person be a partner or not. Can a minor be a partner of LLP? Can minor be a partner of LLP? Yes or no? The answer is no. A minor cannot be a partner of LLP. Only who can be a partner? Major, sound mind, and not declared as insolvent by the court. It can be what? Can be what? Partner of LLP. Okay. Example: X Company Limited is a partner of partnership firm. The partnership firm already has 5 individual partners in it. X Company Limited, by virtue of being limited liability company, can be the what partner? 6th partner, because company can also be a partner. There have been amendments to section numbers of the LLP Act, to the LLP Amendment Act 2021, which has brought about certain offences have been decriminalized. Before, certain offences were criminalized, but now they are decriminalized. That violating these requirements will be punishable with a fine regarding between 2,000 rupees and 5 lakh rupees. That's it, 2,000 rupees to 5 lakh rupees. That is the maximum amount of penalty given in the amendment to the LLP Act. Okay, yes. These requirements include changes in the partners of LLP that has to be intimated, change of registered office of the LLP, filing of statement of account, excuse me, filing of statement of accounts and solvency and annual return, and arrangement between LLP and its creditors or partners, and reconstruction or amalgamation of LLP. These offences have been decriminalized and monetary penalty has been imposed. Before, these provisions were criminal provisions, means if you don't satisfy this, there can be prosecution. But in the LLP Amendment Act 2021, these provisions are decriminalized, means there is only a penalty now. Okay, yes. The amendment has also increased the maximum term of imprisonment from 2 years to 5 years, including a fine between rupees 50,000 rupees to 5 lakh rupees in case of fraudulent activities carried out by an LLP, including defrauding its creditor. So penalty amount is 50,000 rupees to 5 lakh, 50 to 5 lakh, and imprisonment of how many years? 6 months to 2 years. Before it was 2 years, but now it is increased to 5 years. Okay? Yes. Under this act, central government may compound any of the offence. Compounding means compromising under the act, which is punishable only with a fine. So if there is only a fine, then such offences are compoundable offences. The amount imposed may be up to maximum fine prescribed for the offence. The amendment amends this to provide that a regional director appointed by the central government may compound such offences. See, in case if you don't pay income tax on time, there is a penalty. There is a question of compounding over there. But if there is a fine, that offences can be compoundable only by the particular authorities. In the same way, in case of LLP Act violations, if it is punishable only with a fine, the regional directors can compound the offence. Compound means there will not be any prosecution and you agree to pay the imposed amount of penalty. And it also allows the central government to establish a special court for speedy trial of offences under the Act. And this special court consists of a session judge or an additional session judge for offences punishable with the imprisonment of 3 years or more. A metropolitan magistrate or a judicial magistrate for other offences, means which are punishable less than 3 years. Special court is for trying criminal offences. For civil offences, we have NCLT and NCLAT. So, if an offence is punishable under the LLP Act with more than 3 years, then the special court should consist of a session judge. If an offence is punishable with less than 3 years, then the special court should consist of metropolitan magistrate or a judicial magistrate first class. Okay, yes. Members, nothing but the partners. Minimum number of partners, minimum how many? 2. Maximum how many? Unlimited. Okay, but at any time, if the number of partners is reduced below 2, then the remaining partner shall increase that number of partners to how many? Minimum requirement, that is 2. Within how many months? 6 months. What if he carries the business without increasing the number of partners to 2? And after the expiry of 6 months, so if he carries the business without increasing the numbers to 2, after the expiry of 6 months, he becomes personally responsible. To whom? To the all the activities done by him after the expiry of 6 months. Let's say there are 2 partners, X and Y. Y is dead. Who is left? X. Law gives Mr. X 6 months of time to increase the number of partners to 2. If he do not increase, or if he fails to increase the number of partners to minimum 2 within how many months? 6 months. After the expiry of 6 months, whatever happens, who will be responsible? That remaining one person will be personally liable. Means his liability becomes unlimited. After the expiry of how many months? 6 months. So, the remaining member shall increase the number of partners to how many? 2. Within how many months? 6 months. Designated partner, important. Who are designated partners, sir? Like company may we have board of directors. In case of LLP, we have designated partner. Designated partner is the one who manages the affairs of the LLP. And a designated partner should be a natural person, individual, and he must be having DIN number. So only such person can become what? Designated partners of an LLP. Every LLP shall have at least 2 designated partners. The DP shall be individual and at least one of them shall be resident of India. Same like board of directors. Out of them, one shall be resident of India. Who is resident of India? The one who has stayed in India for a period of not less than how many days? 182 days in the preceding 1 year. In the preceding 1 year, if he has stayed for 182 days, then he is considered resident of India. Okay, yes. If the incorporation documents specify who are to be designated partner, such a person shall be designated partners on incorporation. If the incorporation document states that each of the partners from time to time of LLP is to be DP, then every partner shall be what? DP. So minimum how many DP should be there? Minimum 2. Maximum how many? Maximum is not prescribed. Okay, yes. Filing requirement. The one who becomes the partner of LLP, an individual shall give his consent to become DP in the form number 9. The particulars of an individual who have been given his consent to act as DP shall be filed in form number what? 4. The individual who has given consent to act as partner or DP shall file consent in the form 2 along with what? Fees. So the consent to act as partner of the LLP, designated partner of the LLP, shall be in form number what? Form number 2. Consent to become designated partner should be in the form number 9. Disqualification to become partner, rule number 9, important hai. Who is disqualified to be a designated partner? The one who has been adjudged as an insolvent in the preceding 5 years. If he has suspended or any made compromise with the creditors of the company in the preceding 5 years. He has been convicted by any court of an offence involving moral turpitude and sentenced in respect thereof to imprisonment for not less than 6 months. If he is sentenced for not less than how many months? 6 months. He has been convicted by the court for an offence involving section number 30 of the Act. In these cases, he is disqualified to be what? Independent designated partners of the LLP. Done. So, who are the designated partners? Nothing but they are the one who manage the affairs of the LLP. Who can be a designated partner? Only an individual can be a designated partner. Is he required to have a DIN number? Yes, he must have a DIN number. DIN means director identification number, same for designated partner as well as the directors. Liabilities of designated partner. Is he personally responsible? No, his liability is limited. A designated partner shall be responsible for doing all the acts, matters and the things that are required to be done by LLP in compliance with the provision of the Act, including filing of any document, return, statement, report under this Act. It also liable to all penalties imposed on the LLP for any contravention of provisions of the Act. So, if there is any penalty imposed on the LLP for the payment of that penalty, who will be responsible? Designated partners can be held responsible. Important है the liability of designated partners. Next one, vacancy. LLP may appoint a partner within 30 days of the vacancy arising for any reasons. So, if there is any vacancy in the position of a designated partner, that can be filled by whom? Filled by the partners within how many days? 30 days by intimating to the ROCs. Okay, yes. Next, punishment for contravention. If any of the provisions are contravened, then every partner shall be liable with a fine which shall not be less than 10,000 rupees, but which may extend up to how much? 5 lakh rupees. Okay. Formation of LLP. How to start an LLP? What is the formalities to be complied with for LLP, incorporation of LLP? The very first step is reservation of name, same like companies. We reserve the name by using the form called as run by paying a fees of, let's say, 400 rupees. So, reservation of name. Once the reservation of name is done, you have to submit the incorporation form. So, now we have a form called as PILIF form, means form for incorporation of company electronically, limited liability partnership. So, you should fill the PILIF form. And these forms shall be filed with whom? ROC. So, registration of LLP is taken care by whom? Taken care by the ROC itself. And then the ROC will reserve the name. Okay. Payment of fees, it is not 200 rupees, it is 300 rupees now. Okay. Not 400 also, it is 300 rupees is the fees payable for reservation of name. Okay. Upon the receipt of application with the fee, the registrar may, if satisfied, subject to the rules that name to be reserved is not, or which may be rejected on any ground, reserve the name. The reserved registrar shall inform the applicant for reservation or non-reservation of the change time, and the name is reserved for how many days? 60 days. Okay. The name is reserved in case of LLP. The name is reserved for the LLP up to how many days? 60 days, within which you should incorporate your LLP. The application for this purpose shall state LLP identification number, the name in which the LLP or the company or any other ground was incorporated or registered, the grounds of objections of the name of the LLP incorporated subsequently. This has to be specified in the LLP's name reservation thing. So you should mention the name of the LLP and also the object for which the name is to be reserved. The application shall be verified by the person making it, means he has to verify that the contents are true and he is not lying. The authority under which he is making such application has to be specified. Submission of incorporation form. So once name is reserved, you can apply for incorporation of LLP. Okay, you have to state the name of LLP, proposed business of the LLP, address of registered office, name and address of each of the partners and also designated partners, and contribution amount if any, and all these things has to be specified. Okay, so once these documents are prepared, ready, you have to file this with whom? File with the ROC. The statement in the prescribed form made either by an advocate or company secretary, cost accountant or a chartered accountant in practice should be given by the professionals. We have to certify that all the documents are filed with the ROC are true and correct. Incorporation by registrations. Once these form documents are filed with ROC, the ROC will verify the same. If the documents are in order, ROC issues what? Certificate of registration, and ROC will also mention the LLP identification number. Now, what is LLP identification number, sir? It is a number given to the LLP. Like we have a SIN number. What is SIN number? Corporate identification number. Okay, the name shall not be allowed by the registrar if the name is undesirable or if it is identical or too nearly resemble to the name of an existing company, same like companies. The name proposed by the LLP shall not be identical or resemble to the name of what? Existing LLP. Next, is company required to have registered office? Yes. Is LLP required to have registered office? Yes, it shall have a registered office. That is why when we file application form for incorporation of LLP, we do specify what? The place of registered office of the LLP. Effect of registration, section number 14 provides that on registration, LLP shall, by its name, capable of suing and being sued, acquiring, owning and holding, means on the date of registration, LLP becomes a separate legal entity, body corporate, having all the features of a LLP. Okay, tell me, for how many days the ROC will reserve the name? For how many days the name is reserved? 60 days. Very good, Siddharth. 60 days. What is the form you will use for reservation of name? Run form. Reserve unique name. Done? Yes. And the name shall always end with a word called as limited liability partnership, an acronym called as LLP. That should be part of your name. Okay? Yes. Service of documents. Tell me, if you want to send any documents to the LLP, where you will send? At the registered office of the LLP. That is the reasons why we have registered office, right? To serve the documents. The documents will be served on LLP or a partner, a designated partner, by sending it by post or under the certificate of posting, or by registered post or electronic communication, or by courier at the registered office. What office? Registered office. LLP shall give an address for service of document within the jurisdiction of the ROC where it is registered office is situated. Such address shall include the PIN code, email address, everything. The intimation of other address for service document shall be given to registrar in form number 12 within how many days? 30 days. So if there is any service of intimation to the LLP, the same should be informed to the registrar also. Section number 13, change in the registered office. Can LLP change the registered office? Yes, by following the procedure laid down in the LLP agreement. But in case of company, it has to be done as per what? Companies Act. But in this case, it has to be done as per the LLP agreement. If there is no such agreement, the consent of all the partners shall be obtained. Most important, you can change the registered office as per what? As per what? LLP agreement. If the LLP agreement is silent, then the change can be made. What can be made? The change can be made only with the consent of whom? Consent of all the partners. Consent of whom? Consent of the all partners will be required. Generally, a LLP agreement, that is for change of registered office of the LLP, can be done as per the formalities prescribed in the LLP agreement itself. But if the LLP agreement is silent, then the law provides that all partners should give the consent for change of registered office. A LLP having secured creditor shall also obtain the consent of whom? Such secured creditor. The notice for change of registered office shall be given to registrar in form number 15 with respect to change of registered office. Within how many days? 30 days. If the change in the registered office is from one state to another state, the LLP shall publish a general notice not less than 21 days before any notice with the registrar in a daily newspaper in English and in the principal language and of the district, that is one in vernacular language, one in English newspaper. Change of name. Rule number 20 provides that any LLP may change its following procedure laid down in the LLP Act. Okay, LLP agreement itself. If LLP does not provide, then the LLP's name can be changed with the consent of whom? With the consent of whom? All the partners. Consent of whom? Consent of the all partners. Okay? Yes. So these are the ways in which LLP is incorporated. Can name be changed? Yes. Change of name by central government. When central government can order for change of name. We discussed it now. Whenever the central government is of the opinion that the name of the LLP is identical or resemble too nearly to the name of an existing LLP, then it may ask the new LLP to change what? Name. In that case, the LLP shall change the name within how many days? Within 3 months after the date of direction. Next comes the rights and the duties of the partners. What? Rights and duties of the partners. Schedule 4, chapter number 4 of the LLP Act deals with what? Partners and their relationship. Okay. Chapter number 4 of the Act deals with the partners of LLP and the relations between them. The LLP is governed by the LLP agreement. Which agreement? LLP agreement made between the partners. Made between partners. The persons who subscribe their name to the incorporation document shall be its partners on the incorporation of LLP. So one who has signed the LLP agreement will be considered as what? Considered as partners. The agreement is vital document in the LLP transactions. An agreement made in writing before the incorporation of LLP between the persons who subscribe their names to the incorporation document may impose obligation on the LLP. For this, such agreement is to be ratified by all the partners after the incorporation of LLP. After the incorporation of what? LLP. The LLP shall file such informations in form number 3 with the registrar within 30 days from the date of ratification by all the partners along with the fees. So, ratification means what? Means corrections. If the LLP agreement was made before registration of LLP, then the same can be ratified by whom? Ratified by all the members by passing a resolution. By passing what? Resolution. And the same shall be intimated or informed to whom? ROC in the form number what? LLP 3. Form 3 is the form which is required to be filed with the ROC for the purpose of what? Intimating any change or if the intimating ratification of partnership agreement, LLP agreement. Tell me the rights and the duties of the partners are governed by which agreement? What agreement? LLP agreement. Is it required to be filed with the ROC LLP agreement after incorporation? Yes. Within how many days of registration or incorporation? Within how many days you are supposed to file the form 3? Within 30 days. What if the LLP agreement was made before incorporation? Is it required to be ratified? Yes, it needs to be ratified. Within how many days of after registration? Within 30 days. Okay. The mutual rights and duties of the partners of LLP and mutual rights and duties of LLP and its partners are governed by which agreement? LLP agreement. But if the LLP agreement is silent, that shall be governed by what? Governed by the LLP Act. And every LLP shall file information with regard to LLP agreement in the form number 3 with whom? Registrar. Within how many days? 30 days. How many days? 30 days. Important hai. In the absence of agreement to as any other matters, means if the agreement is silent with respect to what? With respect to the rights and duties of the partners, then the rights and duties of the partners are governed by what? Governed by what? Governed by the LLP Act, which provides that the following: the mutual rights and duties of the partners and mutual rights and duties of the LLP and the partners are to be determined by the provisions with respect to the first schedule. First schedule to the LLP Act provides what? Mutual rights and duties of the partners when the agreement is silent. So the first one says all the partners of LLP are entitled to share equally in the capital, profits and losses of the LLP. They have a right to share the capital, profit and the losses of the LLP equal ratio. If agreed ratio, not agreed equal ratio, that is what the law says. LLP shall indemnify each partner in respect of payment and personal liabilities incurred by him. Every partner shall indemnify the LLP for any loss caused to it by his fraud. Every partner may take in the management of the LLP. So everybody can be a designated partner. But if the agreement provides otherwise, let's say it says only X and Y are designated partners, only they act as a designated partner. No person may be introduced as a partner without the consent of all existing partners. No name change can happen without the consent of all the partners. No change of registered office can happen without the consent of all the partners. These are applicable only when the agreement is silent. If agreement provides otherwise, you have to follow the agreement. So only when you are not included all these things in the partnership deed, then the law says these are the rights. Okay. Every partner shall render the true accounts and full information of all the things affecting the LLP to any partner or his legal representatives. If a partner carries on any business of the same nature as and competing with the LLP without the consent of LLP, he must account for and pay over the LLP all the profits made by him in that business. If he carries out competing business with the LLP, same business, has similar business of LLP, that he has to account to the LLP. He can't do that. And there can't be any expulsion of a partner. So because agreement, see, expulsion means removal. Expulsion can happen only when there is a provision in the agreement. If agreement is silent, LLP Act provides, Schedule 1 provides, you can't expel a partner. These are the rights and duties of the partners when the agreement is silent. Cessation of partnership interest means in what scenarios a partner ceases to be a partner. First one, in the absence of such agreement, if a partner who intends to resign may give his notice in writing to not less than 30 days to other partners. Means if I want to retire, I can retire by as per the agreement. If agreement is silent, law says you have to give 30 days prior notice. Means if I give a notice today, I deem to be ceased to be a partner after 30 days of this notice. So a partner shall ceases to be a partner of the LLP on the following grounds also. That is, first one is voluntary, second one is involuntary. On death or dissolution of LLP, declared as unsound mind, or he is adjudged as an insolvent. In these cases, he has to be a partner. Liability of seized partner, where a person has ceased to be a partner of LLP, he is to be regarded as still being a partner of the LLP unless the person has noticed that the former partner has ceased to be a partner of LLP. Means a public notice must be given. He has to intimate to the ROC saying that he no more a partner. If public notice is not given, and if anyone gives a loan to the partnership firm believing that a person is a partner, he will be held responsible. Okay, partner by holding loan. Entitlement to the seized partner. The seized partner, that is outgoing partner, is entitled to what? An amount of equal to the contribution of the former partners actually made to LLP. Nothing but he can recover his capital. Has a right to share in the accumulated profits of the LLP. Accumulated profits of the LLP after the deduction of accumulated losses of the LLP determined as at the date the former partner ceases to be a partner. So he can recover the amount equal to the capital contribution, and also he can recover accumulated profits of the LLP. Clear? Let's say if I am going out, or if the partner is dead, his legal representatives can recover the amount equal to his share of capital as well as amount equal to surplus in the profit. If there is no surplus, sir, isko kuch nahi milega. Okay. Registration of changes in partners. If there is any changes in the details of the partner, the same shall be intimated within how many days? 15 days of such change in the form number 6. To whom? To the ROCs. And sorry, LLP. LLP shall file notice of registrar where a person becomes or ceases to become partner in the form number 4, or where there is a change in the registrar address of the partner in the form number what? 4, within how many days? 30 days. So any change in the information of a partner, whether with respect to name or address or any other things, that shall be filed to the ROC in the form number 4 within 30 days. If not, there is a penalty. What is the penalty? Punishable with a fine which shall not be less than 2,000, maximum up to 25,000. LLP may file the registrar a notice if he has reasons to cause to believe that. LLP may not file a notice with the registrar. Okay, if the partner has a reasons to believe that the LLP will not file it, who can only file it? The partner himself can file it. Liability of LLP, chapter number 5 provides that liability of the LLP is liability of the LLP limited, partners is limited, not the LLP. So LLP is liable if a partner of LLP is liable to any person as a result of wrongful act or omission. Let's say we have a partnership, LLP, limited liability partnership. In this case, we have authorized Jashwant to do something. While carrying out that activity, he has done a fraud. We will not be responsible. Partners will not be responsible. But who is responsible? LLP is responsible because LLP is a person. So, for the act of a partner, who will be responsible? LLP only responsible, not the other partners. Okay. LLP is not bound by anything done by a partner in dealing with a person if the partner has no authority to act. So, what if a partner goes beyond its powers? Is LLP responsible? Answer is no. Only if a partner does anything within these powers, acting in good faith, or with a person who is acting in good faith, then only LLP is responsible. Section 29 of Section 2 provides that where any credit is received by the LLP as a result of representation of a person to be partner of LLP, shall also be liable to the extent of credit received by it or any financial benefit derived thereon. Partners as agent, as I said, partners are the agent of whom? LLP, for only authorized act, not for unauthorized act. But is a partner is an agent of another partner? The answer is no. Liability of a partner. A partner is not personally liable solely by reason of being a partner of LLP. Correct now? Because liability of the partner is limited. But he will be personally liable for his own wrongful act or omission. While carrying the partnership business, if he commits any wrongful acts, he is personally responsible. But if one partner does a wrongful act, is the other partner responsible? No. But for the wrong of one partner, who is responsible? LLP is responsible. Okay, because a partner is the agent of LLP but not the agent of other partner. Done? Yes. Section 29 provides that any person who by words spoken or written or by conduct represent himself or knowingly permits himself to be represented as to be a partner in the LLP is liable to any person who has on the faith of such representation given credit to whom? LLP. Partner by holding out. Section number 29. A person is not a partner, but he by his words represent himself as a partner to a third party who, believing on such representation, provides a loan to the partnership firm, that is LLP. Then the person who has made representation that he is a partner even though he is not, he will be held responsible as what? As a partner in the LLP. Unlimited liability. Generally, the liability of the partners is limited. But where an act is LLP is formed with the intent to defraud the creditors or the LLP, then the liability of the LLP and its partners shall be unlimited to all or any of the debts or other liabilities of the LLP. If the intention of the LLP is lawful, then the partner is responsible only to the extent of his contribution. That's it. LLP में partners का liability is limited. Only if the partnership firm, that is LLP, limited liability partnership firm, is formed with the intent to defraud the creditors, in that scenario all the partners will be held responsible even personally also, because their liability becomes unlimited. Okay. Section number 31 provides that reduction of penalty awarded according to 31 of the code. A tribunal may reduce or waive any penalty imposed on any partner or employee of LLP if it is satisfied that such partner or employee of LLP has provided useful information during the investigation of such LLP. Means court may waive or reduce the penalty imposed on an employee or partner of LLP if they are given any useful information or they are provided any evidences which will lead a person to found guilty. In that cases, the LLP may reduce or waive the penalty applicable to a persons. Okay, and no partner or employee of an LLP may be discharged, demoted, suspended, threatened, harassed, in any other manner discriminated against the terms and conditions of LLP just because he has given information. If they do, it is illegal. Contribution. What is contribution? As I already discussed, nothing but capital, correct now? So contributions includes what? Includes tangible and intangible properties brought in by the partners, movable and immovable property, other benefits including money, promissory note, other agreements to contribute cash or property or contract for service performed or to be performed. The money value of contribution of each partner shall be accounted for, shall be what? Accounted for and disclosed in the accounts of the LLP. The money value of contribution of each partner shall be accounted, means recorded and disclosed in the accounts of what? Accounts of the LLP. The same shall be valued by the practicing CA or a practicing cost accountant or by approved valuer from the panel maintained by the central government. The account should be valued by the practicing CA or practicing CMA. Maintenance of books and accounts important hai. Every LLP shall maintain the books of accounts and these books of accounts shall be get audited. Okay, only if the turnover goes beyond 50 lakh rupees. Okay, and this company shall file form number 8. Form 8 is the statement of accounts and solvency. This has to be filed within 6 months from the end of the financial year. Okay, yes. Books of accounts. Every company LLP shall maintain the books of accounts on accrual basis, receipt of all money as well as money expanded. These details has to be maintained for how many years? 8 years. The statement of accounts and solvency in the form number 8 shall be filed within a period of how many months? 30 days from the date of 6 months. Correct hai? end of financial year is 31st March. From that date 6 months plus you will get 30 days of time to file the statement of accounts and solvency. If LLP has closed financial year on 31st March 2011, it shall file the statement of accounts and solvency in the form number 8 with the registrar within a period of how many days? 30 days from the date of end of 6 months, not 60 days, it is 30 days. The statement of accounts and solvency of an LLP shall be signed on behalf of the LLP by a designated partners. Important है, auditing of LLP's accounts is compulsory only when the turnover contribution exceeds 25 lakh rupees and turnover exceeds 40 lakh rupees. So only when the contribution amount is more than 20 lakh, capital is more than 25 lakh and turnover is more than 40 lakh, what is compulsory? Auditing of accounts of LLP is compulsory, otherwise it is not compulsory. And a statement of accounts and solvency of the LLP should be filed with whom? ROC. Within how many days of end of financial year? Within 6 months from the end of financial year, plus you should add 30 days of time to it. Appointment of auditor. A chartered accountant in practice is qualified for what? Appointment as an auditor. He shall be appointed for each financial year of the LLP. The designated partner may appoint an auditor at any time in the first financial year, but before the end of the first financial year. At least 30 days prior to the end of each financial year, you have to appoint the whom? Auditor. To fill a casual vacancy in the office of auditor, including the case when turnover or contribution of LLP exceeds the limit. Who has the power? LLP has the power. To fill the casual vacancy caused by removal of the auditor. So if it is removed, partners has the right. If a designated partner have failed to appoint an auditor, the partner may appoint an auditor or auditors. An auditor appointed shall hold the office in accordance with the terms of their appointment and shall continue to hold such office till the period of the new auditor appointed or they are reappointed. Rule number 24, sub-rule 14 provides that where no auditor has been appointed, any auditor in the office shall be deemed to be reappointed unless the LLP agreement requires actual reappointment or majority of the partners have determined that he should be reappointed and have given notice to that effect to the LLP. So he is deemed to have been reappointed, the same auditor of the company. Removal of auditor. LLP may remove an auditor from the office at any time in the following the procedure laid down in the LLP agreement. If the LLP agreement does not provide, then the consent of all partners is required. Remember this, wherever LLP agreement is silent, then that has to be done only with the consent of all the partners. Can auditor of a LLP resign? Yes. Auditor of an LLP may resign from his office by depositing a notice in writing to that effect at the LLP's registered office. If an auditor is not willing to be reappointed, he shall give a notice in writing to the LLP not less than 14 days before the end of the time allowed for appointing the new auditor. And in that case, the new auditor will appoint the auditor, a company LLP will appoint the new auditor. Annual return important hai. You should file annual return in the form number 11 along with the fees. So filing of annual return is compulsory within 60 days from the date of end of financial year, that is from the March, April, May. May is the last date for filing the annual return. We should file the annual return in the form number 11. Important, okay? Statement of accounts and solvency, form number 8. Annual return, form number 11. Inspection of documents. The following documents of LLP shall be available with the register for inspection by any person on payment of fees. What are documents? Incorporation documents, name of the partners and changes, statement of accounts and solvency, annual return. These are public documents and anybody can inspect it. Penalty for false statement. If you are given any false or incorrect informations, who can make investigation? ROC. And there is a penalty of imprisonment up to how many years? 2 years, and a fine which may extend up to 5 lakh. Powers of registrar, section number 38 gives the power to registrar to obtain such information may require any person, including a former partner, designated partners, employees of LLP, to answer any questions or to make any declaration. So he has the right to inspect, ask for explanations, and also he has the right to demand any person to appear before him and to provide the explanations. Okay, so then the partner should provide the explanations within the prescribed time. That is compounding of offenses. We have discussed this up to any offense which is punishable only with a fine. Are they compoundable? Yes, central government. That is, we can make an application to the regional director and they can compromise. Compromise without any prosecution. See, generally what happens, if there is a contravention of any provision of the law, even in case of Income Tax Act, the ROC, the concerned department of the government will initiate what? Prosecution. They file a case, then hearing will happen, then the court will decide the fine. But if it is a compoundable offense, the parties can compromise without going to the court. That is called as compoundable offense or compounding of offense. Okay? Yes. Preservation of record. The following records are to be preserved permanently. What are the documents to preserve permanently? Incorporation document, notice of situation of registered office, information with regard to LLP agreement, notice of other address of any LLP partnership. The following documents are to be preserved for 21 years. You can go through this, the list we have, all these statement of compliance with requirements, correspondence with respect to LLP, registered documents of LLP, copies of government orders, notice of persons, annual return, consent of candidate, consent to act as partner, statement of shareholders. All these documents are to be preserved for how many years? 21 years. Okay. So then we have deduction for old records. The registrar shall maintain the register of destroyed documents in two parts, wherein you will center brief particulars of the records destroyed and shall certify therein the date and the mode of destructions. Okay, so these are the provisions of the LLP Act. We have only 82 section numbers of LLP Act. So in this part we have discussed how to incorporate a LLP, the documents to be filed with the registrar for incorporation of LLP, liabilities of the partners, liabilities of the LLP, statement of accounts, statement of solvency, appointment of auditor, resignation of auditors, all these things. And we also discussed the mutual rights and duties of the partners of LLP. We know that LLP Act has how many schedules? It has 4 schedules. Schedule 1 provides the mutual rights and duties of the partners when the agreement is silent. Schedule 2 provides the conversion of private company into LLP. Schedule 3 provides conversion of private company into LLP. Schedule 4 provides conversion of unlisted public company into LLP. So we will discuss one by one conversion of private company into LLP, partnership firm into LLP, then conversion of private limited into LLP, then conversion of unlisted public company into LLP. Then we will discuss effect of registrations. After that we will discuss about foreign LLP. Okay, and then we will discuss about reconstructions, mergers of LLPs. Then we have one last chapter called as dissolution of LLP, how to close the LLP, what are the formalities to be complied for LLPs. Okay, we'll take a small break. After the break we'll continue with the how to convert, once again, how to convert the limited liability partnership. Okay, so let's take a small break of 5 minutes. Join back by 12:16. We will continue with the conversion of LLP. Okay, we will discuss conversion of private company into, partnership firm into LLP. What are the documents to be filed and what are the formalities to be satisfied. Take a break. Yes, guys, welcome back. Let's start with conversion of partnership firm into LLP. So, second schedule of the LLP provides conversion of partnership firm into LLPs. So, defines that the term convert in relation to partnership firm converting into LLP means the transfer of property, assets, interest, rights, privileges, liabilities, obligations and undertakings of the firm to LLP is called as what? Conversion of partnership firm into LLP. A firm may convert into LLP on condition that the partners of the partnership firm shall be bound by the provisions of the second schedule that are applicable to them. So, the conversion shall happen as per the second schedule of the LLPs. So, the partners of the partnership firm, no other person will be allowed to be what? Allowed to be a partner of LLP. This is the first condition. First important condition is that all the partners of the partnership firm should become partners of the LLP and no other person can become partner of LLP. A firm may apply to the registrar by filing a statement by the partners in the form number 70, the name and registration number, the date on which the firm was registered under the Indian Partnership Act, incorporation document and statement, and on the receipt of above said document, the registrar shall register the document and issue what? Certificate of registration in the form number 90. The LLP shall within 15 days of the date of registration inform the concerned registrar of firms with which it was registered under the provisions of Indian Partnership Act about the conversion and the particulars of LLP. This is how what happens. Registration of conversion of partnership firm into LLP is done. You have to file a documents with the ROC and all the partners of partnership firm should become partners of what? Partners of LLP. Conversion from private limited company to LLP. Can we convert a private company into LLP? Yes, it can be done. Okay, how it can be done? So, all the rights, privileges, duties and liabilities of the private company should become part of what? LLP. A company may apply to convert itself into LLP only if there is no security interest on its assets subsisting, means there should not be any loan on the assets of the company. The partners of the LLP to which it converts comprise all the shareholders of the company and no one else. So, all the shareholders of the private company shall become the members of the LLP after the conversion. The company shall apply to the registrar by filing the following documents: statement by shareholders in the form number 18, incorporation document and statement. On the receipt of such documents, the registrar shall register the documents and issue the registration in the form number 90. The LLP shall inform the concerned registrar of companies within how many days? 15 days of date of registration about the conversion and the particulars of LLP in the form number along with the fees. Conversion of unlisted public company into LLP. Sir, can we convert listed companies? Sir, no, only unlisted public companies. Again, what is transfer? Convert means when all the assets, liabilities, property and interest of the transferred company becomes a part of the LLPs, and only the members of public company becomes the partners of the LLPs. Okay, and it does not include the listed companies. A company may apply to convert into LLP if any, only if there is no security interest and its assets subsisting in the force at the time of application. The partners of LLP to which it converts comprise all shareholders of the company and no one else. A statement by all its shareholders in the form number 18 along with the fees containing the following particulars should be filed. On receipt of the above statement, the registrar shall register the document subject to the provisions of Act and the rules made thereunder. So, once the ROC issues a certificate, the registration takes effect. Simple, guys. Conversion of partnership firm, all partners should become part of the LLP. Same even in case of private company or unlisted public company, and there has to be a statement by the existing partners, members in case of private company or public company, and they must also deliver the certificate of registration to the LLP, the ROC, Register of Companies. ROC will verify everything and then he issues a fresh certificate of registrations and LLP comes into effect. Effect of registration, there shall be a LLP by the name specified. All tangible and intangible property vested in the company, all assets, interests, rights, privileges, liabilities, obligations with respect to the company shall be transferred to and shall vest in the LLP. And the partnership firm, private company, unlisted public company shall be deemed to be dissolved and removed from the records of register of the firm or register of companies. So that partnership firm is deemed to have been removed. Registration with respect to the property, if any property is registered with any authority, the LLP shall as soon as practicable after date of registration take all necessary steps as required by the relevant authority to notify the authority of the conversion and particulars. Let's say earlier you have registered properties in company name, now you converted it, you should change the what? Records of the registration because it is in the company name, that has to be intimated. Pending proceedings, all the proceedings by or against the partnership firm which was pending before the court or tribunal on the date of registration may be continued, completed, enforced against what? Against the LLP. So whatever the pending offences were there, that will be continued in the LLP's name. Existing agreement, every agreement to which the partnership firm or company was party immediately before the registration date of registration are not of such nature that rights and liabilities could be assigned shall have the effect as from the date as if the LLP has party to such agreement. Instead of company means that contractual rights will continue in the LLP name, even the existing contract as well as the employment. Whoever were the employees of the company will continue in the new LLP. Notice of conversion and correspondence, LLP shall ensure that for a period of 12 months commencing not later than the 14 days after the date of registration, every official correspondence of LLP bears the following, that is, a statement that it was as from the date of registration converted from company into LLP and the name and registration number of the company from which it was converted. You have to mention both old name as well as the new name. For what? Up to how many months? Up to 12 months. These are the provisions with respect to conversion of companies or partnership firm into LLPs. Schedule 2, 3 and 4 of the LLP Act. Then we have foreign LLP. Now name itself, what is foreign LLP? LLP which is incorporated outside India but has a place of business in India. It's called as what? Foreign LLP. So a foreign LLP shall file with the registrar in the form number 27 within how many days? 30 days of establishing a place of business in India. The moment it comes to India, within 30 days, they have to intimate to the ROC a copy of certificate of incorporation or registrations, address of registered or principal office of LLP, the full address of LLP in India, and list of partners and designated partners. All these things has to be intimated to whom? To the ROCs. Within how many days? 30 days. And document shall be notarized by the notary public. If the LLP is incorporated in a country falls outside the Commonwealth, it has to be apostle. Apostle means by the embassy people. It has to be certified by the embassy people, whatever the copies are given. Alteration. If any alteration is made or occurs, same like foreign company. See, once a foreign company comes to India, they shall intimate to the ROC of New Delhi about their LLP agreement. If it is company, companies MOA and AOA. If it is LLP agreement, partners details, who are the designated partners, who is the person responsible in India to do any correspondence, and what are the directors of the company. All those details to be filed with the ROC within how many days? 30 days of commencement of business activities in India. And if there is any changes in the contents of LLP agreement or details of partners, even that is required to be intimated to the ROCs. Okay. The instrument consisting of defining the constitution of LLP, registered or principal office of LLP. The foreign LLP shall file form number INC 28 about such alteration with registrar within how many days of close of financial year? Within 60 days of close of financial year. If any alteration is made in the certificate of incorporation or registration of LLP incorporated outside India, the name or address of the persons authorized to accept the service of notice on behalf of the LLP in India or the principal place of business of foreign LLP, the same shall be communicated with the registrar within how many days? 30 days. If any changes happen, that has to be intimated within 30 days. Translated documents. If any document mentioned above is not in English language, they shall be annexed to the certified translation thereof. You have to attach the translated copy if it is not in the English language. Filing with the registrar within how many days? 30 days. You have to file the financial statement within how many days? 30 days from the date of end of 6 months of financial year. Name to be made noun, you have to display the name of the company both in English as well as the local language, all on the official correspondence and also in the letterheads of the company. Service of document, a document may be served on the company at a registered address in India. Registration, section number 34, rule number 34, subsection number 10 provides that registrar shall on registration of the form 27 issue certificate for the establishment of place of business in India by the foreign LLP in the form number what? Form number 30. Done? Yes. Cessation. If any foreign LLP ceases to have a place of business in India, it shall give a notice to the registrar in the form number 29 within how many days of intention to close it? Within 30 days of its intention to close the place of business. It has to intimate to ROCs. So, in case of foreign LLP, the LLP which is incorporated outside India but has a place of business in India, the moment they come to India, they have to intimate to the ROC. And any changes in the details, again that has to be intimated to the ROCs. Compromise or arrangements. What are compromise? Means when company or LLP compromises with the rights of its creditors or shareholders, it is called as what? Compromise or arrangement. See, compromise happens when there are no disputes. When without disputes, let's say I have taken loan of 1 lakh rupees from Jashwant. I say Jashwant, I can't pay 1 lakh, I'll pay only 90k. He says okay sir, no problem. That is called as compromise. Valid agreement. But when we already have a dispute, he is claiming 1 lakh, but I am saying I am not paying. He has filed a case. Then we can go for our arrangement where we compromise with the rights. So without dispute, if compromise happens, it is called as arrangement. With the dispute, it is called as compromise. I repeat, where there is a dispute between the company and creditors, company and members, then arrangement happens, is called as compromise. Without a dispute, it is called as what? Called as arrangement. So there can be a compromise or arrangement between LLP and creditors, between LLP and its partners. The following may apply before the tribunal for compromise or rearrangement. Either LLP can apply, creditor of the LLP can apply, any partner of LLP apply. In case of LLP which is being owned up, who can apply? Liquidator can apply. Where the LLP is not the applicant, a copy of summons and the affidavit shall be served on the LLP, or where the LLP is being owned up, it shall be served on the liquidators. Upon the hearing of the summons or adjourned hearing, the tribunal shall give such directions as it think necessary in respect of the following matters. Means, if you go for compromise or arrangements, you should file application to whom? NCLT. Now, after receipt of NCLT, what NCLT will do? Hear the parties and decide the matter. Determining the creditors and partners whose meeting is have to be held for considering the proposed compromise or arrangement. Fixing the time and place of meeting, appointing a chairman for the meeting to be held, fixing the quorum and the procedure to be followed at the meeting including voting by proxy, determining the value of creditors of the partners whose meeting have to be held, notice to be given of the meeting and advertisement if any such notice, the time within which the chairman of the meeting is to report to tribunal the result of the meeting and such other matters as the tribunal may deem necessary. Tribunal makes an order for all these matters. So once after that is done, then what will happen? The notice of the meeting is to be given to creditors and partners individually by the chairman or by the LLP. The notice shall be sent by post and a certificate of posting to their known address not less than 21 days before date fixed for the meeting. The notice shall be accompanied by a copy of proposed compromise or arrangement along with a statement material interest of designated partners. The notice of the meeting shall be advertised, if so decided by the tribunal, in such newspaper, such manner as the tribunal direct. Every creditor or partner entitled to attend the meeting shall be furnished by the LLP free of charge within 48 hours of the requisition made for the same with a copy of proposed compromise or arrangement. If they ask for the copy of it, it has provided. The chairman shall file within not less than 7 days before the date fixed for the holding of the meeting, showing that the creditors' directors regarding the issue of notices and advertisement have been duly complied with. If default, the summons shall be posted before the tribunal for such orders as the tribunal may think fit to make. So, whenever there is a proposal for compromise or arrangement, that has to be placed before the NCLT. NCLT orders for the meeting of members as well as the, in case of LLP, partners as well as a creditor. There will be a chairman. The chairman will conduct the meeting and he give report to whom? NCLT. Then NCLT gives the approval. That is when the compromise or arrangement takes place. The proxy shall be signed by the person entitled to attend and vote at the meeting, shall be filed with the LLP at a registered office not later than 48 hours before the meeting. Then chairman of the meeting shall, within the time fixed by the tribunal or where no time is fixed, within 7 days of the conclusion of the meeting, report the results of the meeting to tribunal. Where the proposed compromise or arrangement is agreed to with or without modification by the creditors or partners, 3/4 of its value. How much? 3/4 of its value of the LLP. The liquidator shall present his petition to the tribunal for confirmation of the compromise or arrangement. Where a compromise or arrangement is proposed for the purpose for a reconstruction of any LLP or amalgamations, the petition shall pray for appropriate orders from the NCLT. If the LLP fails to present the petition for confirmation of compromise or arrangement, it shall open to any creditor or partner with the leave of the tribunal. Leave means permission of tribunal to present petition for confirmation, and LLP shall be liable as per the cost thereof. Where no petition for confirmation is presented to, where the compromise arrangement has not been approved by requisite majority, the report of the chairman shall be placed for consideration before tribunal and tribunal may pass such necessary order. If the tribunal is binding on all the creditors or partners and also on the LLP, in the case of LLP which is being owned up, it is binding on the liquidator as well as the contributors. An order of the tribunal shall be filed with the filed by the LLP with the register in the form within how many days? 30 days. An order shall have effect only after it is filed with whom? Filed with the registrar. This is how a compromise or arrangement happens between LLP and its members, partners, or between LLP and its creditors. You need to take approval of whom? NCLT, National Company Law Tribunal. Same thing for companies also. Same thing for whom? Companies also. So when company goes for what? Goes for compromise or arrangements. See, so this is for companies. Okay, कंपनीज के लिए कैसे बनता है कॉम्प्रोमाइज अरेंजमेंट्स एंड अमालगम सेक्शन नंबर 230 to 240. So Tata company, Tata Powers Limited got, there is a merger, because in that merger itself there was certain rearrangement of capital. So because there was certain arrangements to be made in the capital structure, that requires approval of whom? Approval of the NCLT, like approval of the board, application to NCLT. Then NCLT, what it will do? Call the meeting of whom? Creditors as well as the members. Then the chairman will report. At the end, NCLT will sanction the scheme. So once NCLT sanctions the scheme, that arrangement will take effect. The arrangement will come into picture. This is how what happens, compromise or arrangement happens. Okay, this is for companies, and what we discuss is for LLPs, limited liability partnerships. Tell me, does compromise requires approval of NCLT? Do we need to take approval of NCLT for compromise or arrangement? Yes, we must take approval of NCLT. Okay? Yes. This is with respect to compromise or arrangement. They may ask in the examinations the formalities to be complied with for compromise or arrangements. Let's say I have taken 3 lakh loan from Jasmita, but I am not in a position to pay. I'll make an arrangement with her saying that I will pay your entire 3 lakh, but give me some more extra time. I will pay it in installment basis. First installment I will pay 50,000 rupees. Second installment I will pay 25. Remaining installment I will pay 25 after 1 year. This is called as arrangement, and this arrangement can be done only what? By complying with the NCLT order. Okay. Yes. Next. Reconstruction or amalgamations of LLPs. Arrangement for revival and rehabilitation of LLP may be proposed wherein demand by the creditors of the LLP representing 50% or more of its outstanding debt. The LLP has failed to pay the debt within how many days of service of notice of the demand? 30 days of service of notice of the demand. Where petition for winding up of LSP is pending before the tribunal in terms of directions given by the tribunal. Where the liquidator has failed to report before the tribunal in terms of directions given by the tribunal. What can be done? There can be an application for reconstruction or amalgamation. Application before tribunal, you need to apply for statement of account and solvency. Along with that, you should attach particulars and documents relevant to the scheme, proposed reconstruction, rescheduling of debts, or any undertakings from the bank or financial institutions. Proposed scheme of revival and rehabilitation of LLP, including the proposal for appointment of LLP administrator. So, if the LLP is into losses, you can make an application for revival of the LLPs. The application is to be made to the tribunal within 90 days from the date of expiry of the demand notice or from the date of directions of the tribunal. The tribunal may hear all the parties concerned within 60 days of receipt of the application. The tribunal may admit or dismiss the applications. In 60 days time, it may admit the application or it may reject the applications. Hold the meeting of creditors and also prescribe procedure to be maintained by the LLP administrators. Now, who is LLP administrator? The LLP administrator shall be appointed from a panel maintained by the central government for winding up and dissolution of LLPs. The term and conditions of the appointment, including the fees payable to LLP administrator, shall be such as may be ordered by whom? By the tribunal. The tribunal may, on a reasonable cause being shown and for reasons to be recorded in writing, remove the LLP administrator and may appoint another LLP administrator. In case of removal, death or incapacity of an LLP administrator, the tribunal may appoint another LLP administrator. Because company is in losses, for the revival of LLP, you may appoint whom? LLP administrator, and he has to act and report to the NCLT. The LLP administrator shall submit his preliminary report, including decisions and the meeting of tribunal, within how many days of order of tribunal? Within 60 days. On consideration of his report and other materials available, if the tribunal is satisfied that creditors representing the 3/4 in value, this is what important, that against the LLP have with or without modification of the scheme, then it has to be reported to the NCLT. If 3/4 in value does not agree for revival system, then what will happen? Proceedings for winding up of LLP be initiated, LLP be wound up or liquidated to continue, sanction of arrangement for revival and rehabilitation of LLP. So these are the orders who can pass. NCLT can pass if 3/4 in value of the creditor does not agree for revival of the LLP. Order of tribunal. The order of sanction of the arrangement by the tribunal may make provisions for all or any of the following: powers and functions of the LLP administrator, time period within which various actions proposed in the arrangement to be completed, any such direction to the LLP or its officers or to the creditors or to the LLP administrator or to any other person as may be considered necessary, any other order or orders as may be considered necessary. The LLP administrator shall complete all the action with respect to implementation of the scheme and submit his final report before tribunal within such time directed by the tribunal but not exceeding 180 days of the order. So the revival scheme should be submitted by the administrator within how many days? Within 180 days. Section number 62 provides that where an application is made to tribunal for sanctioning of compromise or arrangement which relates to reconstruction of LLP or amalgamation of 2 or more LLPs under a scheme, the whole or any part of undertaking of the property or liabilities of any LLP in the scheme is to be transferred to whom? Another LLP. Tribunal may either by the order sanctioning the compromise or arrangement or by subsequent order make provisions for the matter like transfer to the transferee. Means while ordering it, NCLT may also order for transfer of properties, liabilities as well as any other rights. Enforcement of duty to make returns, etc. Section 41 provides that in case any LLP is in default in complying with provisions with respect to filing with the registrar of any return, account, other documents or giving of any notice to him, the registrar may make an application before the tribunal for making an order for directions in order to make good the default within the time frame. Assignment and transfer of partnership rights, all will be transferred to the new partnership firm or which is reconstructed. Investigation, central government can carry out investigations of LLPs if there is any alleged fraud or irregularities. There are two types of investigation. One is on the order of court or tribunal, other is by the central government itself, suo motu. Investigation on the orders of court or tribunal, central government shall appoint one or more inspector to investigate what affairs of the LLP. If the tribunal suo motu on its own or an application received from not less than 1/5 of the total number of partners of LLP by order declares that affairs of the LLP ought to have been investigated, or any court by order declares that affairs of the LLP ought to be investigated, in that scenario there can be an investigation of what? LLP. Investigation by central government, on what grounds? They may ask this question. Such appointment may be made if not less than 1/5 of number of partners make an application with supporting evidence to the central government. It may order for investigation by inspector. If the LLP make an application that affairs of the LLP ought to be investigated, or if in the opinion of central government there are circumstances suggesting that the LLP is carrying the business with the intent to defraud its creditors for fraudulent purpose, unlawful purpose, manner which is oppressive, unfairly prejudicial to some or any of its member, or LLP was formed for any fraudulent or unlawful purposes, then the central government may order for what? For investigations. By whom? By the inspector. Inspector under power. So when carrying out the inspector, he is governed by the CRPC, Criminal Procedure Code. He can enter any place with the permission of special court. He can seize the books and he can keep the books of accounts. The inspector may require entity to furnish such information, produce such books and papers before him or any authorized person by him. The inspector may examine on oath any of the entity, partner, DP, affairs of the LLP and may administer an oath accordingly, and for that purpose he may require any of the person to appear before him personally. These are the powers of whom? Inspector. The magistrate may by order authorize the inspector to enter any place with such assistance and to seize the books of accounts, search that place or those places in the manner specified in the order, and seize the books and paper with the inspector consider necessary for the purpose of his investigation. And then the inspector give a report to the central government, and central government may initiate a prosecution or may not initiate a prosecution. Means they may file a case, criminal case, or they may not file a criminal case. It shall be the duty of all the partners, DPs, employees and agents to give assistance to whom? To the inspector who is carrying out the investigations, and they also provide a connection with the prosecution which they are reasonable to able to give. Section number 51 provides that if it appears to central government from the report made by the inspector that it is expedient to do so by reason that business of the LLP is conducted in an unlawful manner, then the LLP not being conducted in accordance with the provisions of the act may take actions for what? Winding up of the LLP, that is closure of the LLPs. So these are the ways in which what is done? Investigation is done. Expenses of investigation, the investigation expenses to be borne by the person who has asked for investigations. Inspector's report to be evidence. Whatever the inspector report is given, that is the evidence for the purpose of carrying out the activities. Section number 37 is important. They may ask question in the examination. Strike off of name of the defunct LLP. Now what is defunct, sir? Means the one which is not functioning is called as defunct LLP. Where a LLP is not carrying on any business operations for a period of 2 years or more, and the registrar has reasonable cause to believe the same, suo motu action for striking off the name of the LLP. In this case, the registrar shall send a notice to the LLP and all its partner intimating his intention to strike off the name of the LLP from the registrar. So RO will send notice to whom? To the partners, saying that because you are not carrying any business, we are going to strike off. And send their representation along with the relevant copies. If the company LLP don't want them to strike off, they can make a representation to the registrar within a period of how many months? 1 month from the date of receipt of notice. If the LLP is regulated under the special law, the notice shall also be accompanied by the approval of regulatory body under the law. On the expiry of the notice period, the registrar may by an order, unless cause to the contrary is shown by the LLP, the registrar is satisfied that name should not be struck off the registrar and shall publish notice in the official gazette. On these, the LLP shall stand dissolved. So once the notice is published in the official gazette, the LLP is deemed to have been struck off, removed. The liability of every DP of the LLP dissolved shall continue and may be enforced as if the LLP had not been dissolved. Where LLP is not carrying the business operations for a period of 1 year or more, the LLP in the form number 24 may apply to registrar with the consent of all the partners for striking off its name from the registrar. For this, no notice is required to be issued to the LLP and the partners. Means isko bolte voluntary strike off. So if you are not carrying any business, you can apply to whom? LLP voluntarily, and you can get your LLP dissolved. Okay, that is with respect to LLP Act, where we have discussed conversions as well as the other provisions of the